In the so my senior counsel Peter Gunn is here on the phone at the moment.
Okay.
And he's just to get in, so he's going to try it in another browser just like I did.
Yeah, we had a wee bit of trouble getting in too, but finally we got.
Can you hear Peter when he speaks?
Hi everybody, I'm not sure how clearly I'm coming across on the phone. Can you hear me?
Yes, it's very good.
Yes, clearly. Okay. You still want to try another browser, Peter?
I'm not doing that as we speak.
Okay, brilliant.
I get now to some success story.
If only I could really help you with it.
It's all new for us, isn't it?
Yeah.
The new system. We're the pioneers. Yeah. I think it's quite good, don't you, that we can all meet like this?
Oh, it's fantastic. Otherwise, it would be very hard to meet.
And
I've been not a very good use of anybody's time, so my apologies for the fact that I've not been able to hook into the meeting. And if people are happy enough for me just being on the phone, perhaps we could run it that way and see how we get on at least. Are people happy to proceed along those lines?
Sure.
Yeah.
And I'm sorry, I'm saying people, and that's because I can't see anybody, and assuming that there's more than just Bex on the call, would people like to identify themselves? Don't have to, but if they would, I'm very happy to do that. My name's Peter Gunn, and I'm a lawyer with Crown Law.
okay, we'll start with
And can I start off by saying that one of the things that we accept is that you guys, and I say generally, and you all may have separate or particular concerns about the law in New Zealand, Aotearoa at the moment, but we accept that there are genuinely held concerns. They may be various concerns, but there's certainly a genuine concern about the state of New Zealand law at the moment, and perhaps how it's been developing recently as well. So that's sort of a given from our perspective. We're not suggesting that you're running any sort of false claim here. It's absolutely accept that there are genuine concerns. So I want to make that point right from the outset. The second point is just perhaps to try and explain a little bit about our reaction to your claim. And it's, I guess lawyers are not the most popular profession in the country, probably not in any country actually. But one of the things we do try and do if we are trying to do our job properly is to try and understand the concern that people have and see what we can do about resolving that concern and what's the best way of resolving that concern. So that's what we should be doing as lawyers, and that's what Bex, Rebecca and I are committed to doing in this case, to see what we can do to advance this case along. Not for you, I need to make that plain. Obviously, we're not your lawyers, and we can't act as your lawyers, so we need to be absolutely clear about that. But we are looking to see how we might best resolve this, because a resolution that's in everybody's best interest is often the way in which matters are best resolved. We look for a resolution that everybody, if we can, gets something out of the resolution. But that may not be possible. It's not always possible, but that's what we look looking for. Now, in terms of the issues that we have about the procedures, I think lawyers sometimes get accused of just being wordsmiths. They're too concerned about the words and everything like that. But that concern arises because we need to try and understand a claim that's being brought. And so if you've got a claim that somebody has stolen something from you, you will say, well, this person on such and such a day stole something from me, and I want to get it back, or I want to claim money for the value of whatever it was that was stolen or damaged or whatever. And you can sort of understand that claim, and you put that to the court, and you make submissions from both sides, and eventually the court will rule in favour of the applicant or in favour of the defendant, depending on the court's view of the law. Now, our problem, I guess, with what you guys, and I'm sorry if you guys, not a very nice description, but the claim that's been brought, I should say, is that it just doesn't fit into that sort of type of proceeding. It's not really understood as a claim for damages or a claim for that something's been unlawful or something like that. There's references to various very important parts of New Zealand history, which we acknowledge and accept as important parts of New Zealand history. But then it goes on, and when it gets into the complaints that are made about New Zealand law and the remedies that are being sought, it starts getting a little unclear to us. And I'm not intending to be rude to you by saying that. I'm genuinely saying we are trained lawyers, but we're just having trouble understanding it. And if I look as an example, just as an example, at your first application for relief, you're looking for a declaration.
Did you mean the first prayer for relief?
Yes, the first application for relief under Prayer A declaration.
Are you looking at the prayers, the 4 prayers?
Yes.
Yes, not the cause.
And next to it, not the causes, the prayers and the statement of claim. Is that right, Peter?
Yeah.
That's exactly right.
Yeah.
I've just used this Ardern as an example of the sort of issues that we're facing and responding. The first Prayer A declaration is to consolidate the acts, the Native Rights Acts, and it's not clear exactly what that consolidation would be with. It's not clear to me how they would be consolidated or with what, and where the new declaration deeming European progeny and Native Māori progeny could come from. The court needs a jurisdiction, and I'm sorry again for using technical phraseology, but the court needs a jurisdiction to be able to make a declaration like that. And it seems to me, on the wording in that prayer, that what's being sought is a declaration from the court that the people you identify there, New Zealand people, if you like, are subjects of Her Majesty Queen Elizabeth of the United Kingdom. And there's a legal problem with that because obviously our Queen, same Queen, Queen Elizabeth II, but is the Queen of New Zealand and her realms, not Queen of the United Kingdom, which is a separate country, obviously. So I'm not saying all this to be sort of throwing confusion around or anything like that. I'm just saying those are the genuine questions I have about that prayer for relief or the declaration that's sought there and what it actually means and where it might come from and all the rest of it. So that's just an example of the problems that we have had as we read through their statement of claim. I guess if I can just make a couple of other points and then guys have a response. And I think what I can say is I can stay a bit longer than 2:30. There is pressure on us, as you kindly acknowledged, but we can stay a little later than 2:30, I think. Just to carry on.
Our Zoom meeting will die within 40 minutes, but
it doesn't close. I don't think it closes, because when I set a time on the Zoom meeting, it doesn't close. But if it does, we can come back in, I think. Okay, we hope. Okay, so let's keep going. Okay, keep going. Yeah, sorry.
And my next point is really in terms of some of the concerns that you've expressed in there about the Bill of Rights, the 1688 Bill of Rights, and I can understand your reference to that bill, and the fact that sometimes there can be confusion between that and the Bill of Rights 1990, New Zealand Bill of Rights Act. And sometimes lawyers have that confusion too. So I can sort of understand that, but I'm just wondering what purpose would be served by a declaration saying that the Bill of Rights 1688 is different from the New Zealand Bill of Rights Act. We would acknowledge that that's the case. We'd also acknowledge that the 1688 Bill of Rights is part of New Zealand's law, and comfortable about doing that, because that's the fact of the matter. So there are some things that we might be able to actually agree on. That means that we don't need to actually go to the court and have some litigation over things. And I guess, although the popular view is that lawyers always love to be in court, in fact, that's not always the case, and I think we should be looking to see whether we can resolve situations outside of courtrooms if we possibly can. Now, that doesn't mean that MPs, ministers, public servants shouldn't be accountable. That's a really important part of the work that public servants and politicians do. Accountability is to the electorate and to the wider New Zealand population is not an issue either. But just to pick up on one point you made, Catherine, and just to be clear from our perspective, I don't share your view that this is a means of getting the Prime Minister or the various other ministers, or even Dr. Bloomfield, to give evidence, or even to get for the court to answer your questions. And that would be a matter ultimately for the court to decide. I accept it's not for me to decide that, but I'll tell you why I take that view. And that's because the issues that you're raising in this application are not really questions that the Prime Minister or Chris Farfoy can answer. It's not because they weren't ministers back in 1990 or obviously they were ministers back in 1688 or in 1860. So, but that's not the reason for it. The reason is that they would be called to give evidence on a case if it's a case about their roles and responsibilities. And so if, for example, as in the Ardern case, you were challenging something that Dr. Bloomfield had decided, or something that Andrew Little had decided, then it may well be appropriate to have Andrew Little to give evidence in response to that claim. Usually, there won't be the minister appearing in person to give evidence in response to the claim. It will normally be by way of affidavit in a written form. But in this case, my view of the matter that's been brought is that it wouldn't be a claim that you would call the Prime Minister to give evidence on. I wouldn't be looking to call the Prime Minister in response to this, because these these are not issues that the Prime Minister has sort of responsibility for, unlike a matter that falls within the portfolio of the Minister of Health. And I don't say that to get the Prime Minister or anybody else, including us, off the hook. I think there are other ways of addressing accountability, which may be by way of Official Information Act request. There may be other ways of doing it. But I just want to be clear that as I see the proceedings at the moment, we would not see this as a means of getting ministers in front of the court to answer the sort of questions that you're posing. So I know all of that will be sort of unwelcome and probably you disagree with large parts of it, and that I guess is something that we will need to take back to the court. But I thought it might be useful just to try and set out where I was coming from on this, and hope that you would get a better sense of our problems with what you've put into the court. So that's me, at least at this stage. Sadly, you won't be able to avoid hearing from me again as this carries on, but that's enough for me in the meantime, I think. And Rebecca, I'm not sure if you've got anything to add to that, but if not, then perhaps Catherine or somebody else could respond.
No, I think we should hear from Catherine again.
Okay, so
and I understand that concern. And I think the purpose of this call is to, as I say, try and get a better understanding of what your claim is about, and also to try and explain some of our difficulties in understanding the claim. So I think we've sort of gone through that. In answer to your question about who gets to appear, who would be there as witnesses and so forth, the discussion we're having now is something that we might be able to agree on those points or on other points. But even if we did, we'd have to go to the court and get the court to say, yes, we agree. And so that will be the way things will work. If we don't agree, and we may not agree on whether we need the Prime Minister here, for example, just saying that as an example, I'm not saying that we don't at this stage, but I think it's likely that we don't. But if we don't agree, then we'll go before the court and we'll have an opportunity to say why we think the Prime Minister doesn't need to be there, or maybe even shouldn't be there. And you'll have an opportunity to say to the court, no, what Mr. Gunn says is completely wrong, and the Prime Minister definitely does need to be there. And then the court obviously will make a decision based on the view they take of our various arguments. So don't worry that we're going to agree to anything here that you might get stuck with. If you disagree with anything that we have to say, then obviously we can put that before the judge, and that's the way these things always work. Can I just say a couple of other points before we close that out? Firstly, you referred to some confusing aspects to the New Zealand law and to the New Zealand Constitution, and I don't think that we would necessarily agree with you or disagree with you on that. There are some confusing aspects to it, and I think for some people, and some of them are lawyers actually, it can be a bit hard to understand that the Queen of England and the Queen of the United Kingdom is different, but the same person as the Queen of New Zealand. And those are difficult concepts, even for constitutional lawyers, to understand. I think we certainly agree there are difficult aspects to the New Zealand Constitution. And there may be some aspects that may be able to be clarified by us or you that would help. And that's also have to think about it and see what we can do in that respect. Because again, if we can avoid the time and effort and money that will be involved in going to court, then we should be doing that. So that's what we're going to be doing now. Thank you for everything you've said and the effort you've put into explaining your position. We really appreciate it. We may not agree with you at the end of the day on everything or on lots of things, and I don't want to pretend that we will necessarily, but what I will say to you is we'll go away and we'll have a hard think about everything you've raised and see where we get to on it, and we'll see you. You'll see our memorandum and our response to your claim before the case management conference on Monday, and then obviously on Monday there'll be an opportunity for us both to talk to the judge about things and how the case is going to unfold from there. I understand what you're saying about not being lawyers, and I mean there may be some benefit in talking to somebody who's a lawyer or trying to get assistance through citizens' advice. Those sorts of options are worth considering, I think. But those are decisions again for you guys, and I can't give you advice because I'm a lawyer for the Crown, and I can't give you legal advice. That would be wrong for Rebecca or I to try and do that. So those are issues for you to consider. So can I say thank you again very much for the time and the effort. We have appreciated it. It has been helpful, and we'll go away and have a think about things now, and we'll do our best to come back with a response that makes sense and sets out the Crown's response as clearly as we can.
Oh, that's very, very wonderful. It's been lovely to. I think it would be better.
There may be some benefit in talking to somebody who's a lawyer or trying to get assistance through citizens' advice. Those sorts of options are worth considering, I think. But those are decisions again for you guys, and I can't give you advice because I'm a lawyer for the Crown, and I can't give you legal advice. That would be wrong for Rebecca or I to try and do that. So those are issues for you to consider. So can I say thank you again very much for the time and the effort. We have appreciated it. It has been helpful, and we'll go away and have a think about things now, and we'll do our best to come back with a response that makes sense and sets out the Crown's response as clearly as we can.
Oh, that's very, very wonderful. It's been lovely to. I think it would be better. I was a bit nervous the last when we met at the court, but I'll be a bit better now because I've met Ms. Rebecca and I've had a chance to talk with you.
I still get nervous in court, so that doesn't surprise me at all. Everybody does. Don't worry about that. It's just and the other thing that maybe we could both think about is what are we looking to get out of these proceedings? And that's the question I think we should be asking ourselves. What are we hoping to achieve? And maybe I think you've already sorted out that, but maybe some thinking about that too.
We are asking for an urgent temporary suspension of all laws that affect our constitutional right. That would include the HEPUA, certain United Nations laws, KII, any of that. We're asking for a temporary suspension until we've had our voices heard. So we're going to be asking for the judge for an immediate suspension and including on Marsden Point decisions that they're making, and we will be filing for a temporary injunction immediately on that because we're happy to let these court proceedings drag out for a year or 100 days or whatever time they want. But in the meantime, we're going to ask for an immediate temporary injunction by the Governor-General. I don't know what my legal status is there, but I'm going to be asking them for a temporary relief to the public to just let everybody take a rest for a minute. And I'm going to be asking for that from the judge immediately on Monday. And I will be filing an extra memorandum before Friday as well, explaining why we are requesting a temporary immediate injunction on that. Now, if we can get that, we would be happy to not be so stressed about whether the Prime Minister comes or not, or having meetings to discuss. But at the moment, New Zealand is at critical levels. The people are very, very stressed. We don't know what they're going to do. And I'm going to ask for the court for some temporary relief of that for the public of New Zealand while Ms. Rebecca and yourself and whoever we engaged in talks that we can ask, do we need to take this to court or not? So I'm happy for that. But I am going to be filing that this week. I'll just let you know and I will send a copy to you.
That's helpful to know that, and thanks for that. And that's obviously something you can do. Well, look, can we leave it on that basis at this stage, Catherine, and everybody else? Thank you once again for your time. We better sit down and have a think now about how we're going to respond to all of that, because we've got to file these things and meet the timetable if we possibly can. So we'll spend some time and energy on that now, and we might encounter you next on Monday, I think.
I think so. Thank you so much. Can everybody just say goodbye to you because they're so happy to meet you? I'll let everybody start from